You walk into the plush office thinking the hardest part is finally behind you. Signing the retainer, finding your guy, and knowing someone with a law degree is now on your side of the table. The leather chair creaks, a reassuring smile says, "We've got this," and for a moment the anxiety lifts. But fast forward a few weeks, and the sinking feeling creeps in. Every email from your ex's attorney gets a quick, almost casual looks good from the person you're paying to protect you. Court dates appear on the docket without warning. A vague invoice lands in your inbox, $4,000 for something called case management. You scroll, squint, try to reconcile the number with the 5-minute phone call you barely remember, and a chill slips down your spine. What if the biggest danger in this divorce isn't your ex's demands, but the lawyer you hire to defend against them? Here's the uncomfortable truth. Family law is crowded with attorneys who'd rather glide to an easy settlement than gear up for a real fight. They choose quick signatures over heated negotiations, billable hours over strategic pushes, and polite courtroom nods over the messy work of tearing apart a lopsided proposal. They bank on your stress, your confusion, your need for closure. And by the time you realize they've been coasting, smiling, agreeing, trust me, ing, the assets are divided, the custody schedule is sealed, and your future is locked in a paperwork you barely understand. This video is your early warning siren. We're pulling back the curtain on the 6 telltale signs your attorney isn't grinding for your best interests, but for their own convenience. Because the only thing worse than facing a ruthless opposing counsel is discovering your own lawyer left the ring before the first bell even rang. The first red flag doesn't wave, it whispers. It's the soft, almost soothing phrase your lawyer repeats every time her side sends a proposal. Sure, that's fine. She wants an extra overnight in the custody rotation? That's reasonable. She suggests you cover 80% of extracurriculars because you make more? Makes sense. By the third email, you realize you're paying hundreds of dollars per hour for a human rubber stamp. One that looks official, sounds reassuring, but folds faster than a cheap lawn chair. And each fine by me does more than concede a bullet point. It creates a paper trail of your supposed agreement. Family court thrives on written records. If your attorney never counters, the judge will assume you nodded along. Later, when you finally push back, on that lopsided holiday split or the vague clause that lets her move states with the kids, her attorney slides a stack of unchallenged emails across the table and says, "Your Honor, these terms were presented weeks ago. Opposing counsel raised no objections." Translation: the deal is done, and your silence, purchased at a premium hourly rate, just became consent. Why does it happen? Some lawyers hate conflict more than you do. They fear drawn-out negotiations, believe every fight erodes goodwill, or simply prefer the easy billables of quick settlement to the grind of in-depth strategy. Others figure you're too overwhelmed to notice until it's over. Either way, each unchallenged clause tightens the settlement in her favor while disguising passive acquiescence as professional wisdom. The cure? Demand visible resistance. A real advocate marks up proposals in red, drafts counteroffers that reclaim ground, and explains, line by line, what pushing back could win. If "that's fine" arrives before analysis, translation, and a strategic alternative, it isn't expertise. It's surrender, sold to you at boutique firm prices while your future shrinks with every polite nod. The second warning light flashes on payday when the invoice drops. At first glance, it looks official. Firm letterhead, neat columns, a grand total that makes your stomach lurch. But the details? Foggy at best. Case work, 4.2 hours. What case work? A 10-minute check-in call is logged as 0.6 hours. A quick reply to your anxious text shows up as email review 0.3. And somewhere in the fog, there's a 2-hour block labeled Simply Strategy. You scroll for explanations, but the descriptors are so generic they might as well say doing lawyer stuff. Here's why that should terrify you. In family law, transparency is leverage. A lawyer who breaks down tasks into crystal clear line items, drafting motion, reviewing bank statement, preparing counterproposal, signals organized advocacy. A lawyer who hides behind umbrella phrases is counting on your confusion. Question the bill, and you'll hear, "Those are standard entries," or "The system automatically rounds up." Translation: don't ask. Meanwhile, those padded increments stack like bricks. A 10-minute glance at an email becomes a 30-minute charge. A quick docket check morphs into a full hour. And because you're already overwhelmed by the divorce itself, you pay, telling yourself you'll scrutinize next month's bill. But next month gets worse. Vague time entries protect inefficiency. Phone tag, repeated document searches, last-minute scrambling the day before court. Every misstep can be hidden in case administration. And if you ever dispute the charges, the firm threatens to withdraw, timing the ultimatum right before mediation so you'll cave rather than start over. That's not representation, it's hostage billing. A lawyer fighting for you keeps a ledger you could show a stranger, and they know exactly what was done and why it mattered. Anything less means you're funding a mystery, one that drains your war chest long before the real fight even begins. Your inbox becomes a weather report of silence. Weeks pass with no word until you finally ping your attorney asking, "Any updates?" And within minutes, you receive a rushed summary that feels like a recap of events already set in stone. You discover opposing counsel filed a motion 2 days ago, and the response clock is ticking. A hearing date was assigned last Friday. Rescheduling will require the judge's permission. Mediation materials were due yesterday, but your lawyer assumed you'd gather the documents without being reminded. This isn't just poor communication. It's a red alert sign your case is living at the bottom of their priority stack. A proactive lawyer drives the timeline. They calendar every deadline, send reminders, and brief you before, not after, something lands on the docket. A reactive lawyer waits for you to chase status, then cobbles together an answer that leaves you scrambling. That delay costs more than peace of mind. Last-minute prep means rushed affidavits, missing exhibits, and a courtroom narrative that feels patched together instead of strategic. Judges notice sloppy filings. Opposing counsel exploits them. And every extension request signals disorganization, painting you as the party who can't keep up, even though it's your lawyer who's asleep at the wheel. Meanwhile, the silence breeds anxiety and second-guessing. You refresh email at 2 a.m., wonder if you missed something in the spam folder, and burn mental energy that should be focused on your kids, your work, your recovery. The rule is simple. If you're doing more tracking than the professional you hired, you don't have representation. You have an expensive voicemail that returns calls only when poked. You finally sit down for what you hope will be a strategy session, but instead you get a vocabulary lesson you never asked for. Your lawyer rattles off phrases like pendant light, equitable distribution factors, and best interest standard, then pauses expectantly, as if the sound of Latin somehow equals a game plan. You nod, half understanding, waiting for the translation into real-world moves. How do we leverage those factors? Which evidence supports me? What's the fallback if the judge rules against our first position? Instead, you get a pat on the shoulder and trust the process. That's code for "I don't intend to explain." Lawyers who hide behind jargon aren't safeguarding professional secrets. They're masking the absence of a roadmap. Clear strategy is specific. We'll subpoena her employment records to challenge spousal support. We'll propose a week-on, week-off schedule, then trade summer weeks for holiday parity if they push back. If she argues primary residence, we'll bring the daycare logs showing you did 40% of pickups. Without that level of detail, you're walking blindfolded into mediation, clutching buzzwords that won't impress anyone across the table. Worse, ignorance cripples decision-making. If you don't understand the angle, you can't spot when a settlement offer undercuts it. You sign, later Google the terminology, and realize the clause you accepted undermines the very concept your lawyer paraded in conference. Jargon without strategy isn't expertise. It's theatrical fog, thick enough to obscure the fact that there's no battle plan at all. And when the smoke clears in court, the only person confused will be you, standing beside the architect of your own disadvantage. Emails labeled urgent, deadline extended start piling up like parking tickets. Discovery late? The clerk lost our filing slot. Mediation bumped? Court backlog, not my fault. Motion responses drafted the night before because judge moved the hearing up unexpectedly. After the third excuse, you realize the pattern isn't the system. It's your attorney's calendar tree-off. Every delay benefits only two players. The opposing side, who enjoys extra time to refine their leverage, and your lawyer, who racks up more billable hours scrambling to fix crises they caused. Meanwhile, you foot the bill for overnight document services, emergency notary fees, and Saturday babysitters so you can sign affidavits on zero notice. Worse, hurried filings invite costly mistakes, typos in asset lists that inflate values, missing exhibits that make you look unprepared, procedural missteps that hand the other side easy objections. Judges may grant continuances, but they don't forget which party burns their schedule, and that frustration shadows future rulings. Each postponement also drags out your double housing expenses and emotional limbo. Your ex's lawyer knows this and stonewalls even harder, confident your team will stumble into another extension. The delays create a false urgency that pressures you into unfavorable settlements, because after 6 rescheduled hearings, you'll sign almost anything to stop the clock. When an attorney blames the system for every slip yet never delivers work ahead of deadline, understand, the chaos is a billing model, not bad luck. And that chaos tees up the final, biggest red flag. The sudden push for a fast, lopsided deal before the judge loses patience. A deal that just happens to let your lawyer close the file and collect the last installment of the fee. And then it happens, the pivot from endless delays to breathless urgency. Your lawyer, who has sleepwalked through every deadline, suddenly insists that settling right now is critical. The judge is losing patience. They warn, sliding a proposal across the table that reads like your ex's wish list. Broad custody language that downgrades you to alternate weekends, an alimony duration that outlives your car loan, and an equity split that leaves the house on her side of the ledger while you shoulder joint debts. You balk, expecting a counter strategy, but your attorney doubles down. Litigation will cost a fortune. The outcome is unpredictable. Better to sign and move on. Notice the irony. Cost warnings from the same person who padded 4 months of vague invoices. Predictability speeches from the professional who couldn't predict a single court calendar change. The truth slips out between their rushed sentences. Every extra month your case stays open, they must keep managing their own missed deadlines, strain firm resources, and the risk that you'll notice the pattern and fire them. Closing now locks their fee, avoids malpractice exposure for future blunders, and frees them to chase the next easy settlement. Meanwhile, you're pressured to trade long-term security for short-term relief. Just sign, and everything stops hurting. But the pain doesn't stop, it morphs. 6 months after the decree, you're refinancing debt you should know, begging HR for more time off because alternate weekend fatherhood doesn't cover school holidays, and watching her remodel the kitchen with equity you surrendered in that urgent deal. Remember, a lawyer eager to end the fight on terms that feel lopsided for you isn't forecasting risk. They're offloading their own. A real advocate lays out options, costs, and upside, then asks what you're willing to battle for. If the only option presented is capitulation under a ticking clock, they wound themselves. You're not just underrepresented. You're collateral damage in their business model. A divorce lawyer should be a shield, a strategist, and, when necessary, a brawler. If instead you've hired a rubber stamp who whispers that's fine, invoices like a magician, vanishes until prodded, hides behind jargon, stumbles through deadlines, and then hustles you into a lopsided settlement. Understand this. The problem isn't the legal system. It's the person you're counting on to navigate it. A weak attorney doesn't just drain your wallet. They drain your leverage, handing the other side concessions you'll finance long after the case file is boxed and shelved. They replace strategy with slogans, communication with excuses, and your future with their convenience. You can't rewind a bad decree, but you can course correct before the ink dries. Start by auditing their behavior. Are counteroffers documented and aggressive? Are invoices itemized down to the 10th of an hour? Do you receive proactive timelines, dates, tasks, responsible parties? Do strategy meetings end with clear action steps you understand in plain English? Are filings delivered ahead of deadlines, not minutes past? And when settlement discussions arise, do you see a range of scenarios, best case, realistic case, fallback, or just a single take it or else pressure pitch? If the answers lean the wrong way, act now. Get a second opinion. Most ethical lawyers will review a file for a flat fee, request detailed billing on the spot, demand a written strategy memo, and set weekly status calls that they schedule and summarize. If resistance or excuses follow, you have your clearest proof yet that you're financing your own disadvantage. Fire fast, hire smart, and remember, in family court, the only thing worse than an aggressive opponent is a passive ally who cashes your checks while surrendering your ground. Your kids, your assets, and your peace of mind deserve an advocate who fights like they're living the outcome. Because, in a way, they are